In this section, we are going to learn about aids to interpretation. In addition to the different rules of construction and language, the courts may use different aids to interpret a statute. These aids may be available within the piece of relevant legislation or may be outside sources and materials. They are respectively called internal or intrinsic aids and external or extrinsic aids. Examples of intrinsic aids may be short title of the statute, for example, preamble, section headings, and grammatical usage, something which is found within the Act. These aids are found within the statutes or the relevant piece of legislation, for example, Theft Act 1968, anything within the Act that will be internal or intrinsic aid. Examples of extrinsic aids may include Law Commission reports, for example, Hansard, that's record of parliamentary speeches, textbooks, journal articles, and dictionaries. We will look at these aids separately, but let's start with intrinsic aids in this section. Any statutory words and terms that have been subject to the parliamentary debates are useful and legitimate aids. Such aids may include long and short titles of the statutes, headings, preambles, and punctuations. Apart from the above, the statutes may also contain marginal notes. Sometimes they seem to be explaining some term within the statute and may be considered as an aid to interpret statutes. However, you need to be aware that marginal notes are not debated in the Parliament and are normally not used by the courts for interpreting statutes. Some controversy, however, does exist in relation to the relevance of the marginal notes for statutory interpretation. Please refer to the introductory section to remind yourself of the structure of statute. Let's discuss the intrinsic aids below. Number 1. Long title. Long title is considered as an aid to interpretation, as among others, it gives some information about the purposes of the Act. In the case of Black Clawson International Limited against Pia Workey, Lord Simon stated that the statutory objective is primarily to be collected from the provisions of the statute itself. In these days, when the long title can be amended in both houses, I can see no reason for having recourse to it only in case of an ambiguity. It is the plainest of all the guides to the general objectives of a statute. In the case of Royal College of Nursing of the UK against DHSS, 4 out of the 5 law lords refer to the long title of the Abortion Act 1967. This shows the importance of the long title in interpreting the statutes. Next, intrinsic aid is short title. There is some controversy in relation to whether the short title can be used to resolve any ambiguity in the interpretation of a statute, but it remains an intrinsic aid. Preamble. It's mainly found in old statutes. Preamble means to walk before. This part used to come before the body of the statutes. This usually contained objectives and purposes of the acts, including indication of the mischief to be remedied, and is a useful aid to interpretation. Preamble was stated to be relevant in considering purpose of statutory instrument in Vibixia Limited and Komori UK Limited. It was also stated in another case of R against Corporation of London that preamble is no more than a guide to Parliament's intention, but it is a guide. Then there is a definition section. Statutes may contain definition sections at the start or towards the end of a statute. Usually the words are expressly defined in the definition sections and may refer to other statutes on the similar subject or area of legislation. The words are given special meaning in such sections to give effect to the parliamentary intention and are of fundamental importance to interpret the related statutes. For example, in the Road Traffic New Drivers Act 1995, Section 9 states that the word notice in the Act means notice in writing. This means that a verbal notice may not be a valid notice under the Act. So hence, meaning of the word notice in this statute will only be noticed in writing. Another example is Section 5.2 of the Animal Boarding Establishments Act 1963, which defined animal as any dog or cat. This means cow is not considered as an animal under this act. Hence, there is a difference between legal English and normal English. Legal English is not confined to special meaning, but it has been further defined in case law by statutes, and one word may contain more than one meaning in different statutes. Marginal notes. Chandler against DPP, the court held in this case that the word espionage in Section 1 of the Official Secrets Act 1911 includes sabotage. The marginal notes of the statutes refer to spying. The court ignored the notes, and the word spying was not used to interpret the statutory words. That's how intrinsic aids are treated, depending upon their nature. Explanatory notes. Explanatory notes are used by the courts to seek assistance in the interpretation of statutes. In the case of R.S. against Chief Constable of South Yorkshire, Lord Stein stated that insofar as the explanatory notes cast light on the setting of a statute and the mischief at which it is aimed, they are always admissible aids to construction. He further added that they may contain much more immediate and valuable material than other aids used by the courts. In the case of R against A, Lord Hope stated that it is legitimate to refer to the explanatory notes to the Act, prepared by the Home Office for the purpose of clarification. He stated that he would use the explanatory notes in the same way as he would use the explanatory notes attached to a statutory instrument. Another aid is section headings and side notes. This has been stated in R against Montilla that section headings and side notes are admissible aids to construction. Punctuations. Punctuation can be considered for statutory interpretation as it is expected that expert draftsmen have used them for a reason. Lord Lowry stated in the case of Hanlon against Law Society, to ignore punctuation disregards the reality that literate people, such as parliamentary draftsmen, do punctuate what they write. Punctuation is very important. And as we stated in our introductory lecture, that an Oxford comma made a big difference to a case in the United States. Schedules. They can be absolutely necessary aid to the interpretation. Hunting Act 2004 provides exemptions in its Schedule 1, for example, if hunting is within a class specified in that schedule. Some schedule may contain definitions of different words used in the statute. Some schedules may refer to other statutes and acts for further explanation. In the next lecture, we will look at extrinsic aids. See you in the next lecture.